Welcome again, everybody. It's now the time for the second panel, and we have two speakers. I will briefly introduce the first, which is Professor González Pascual Maribel. She's currently teaching at the Pompeu Fabra in Barcelona, and she will be talking about fundamental rights and the European Union. She's coming from a big Mediterranean city, as well as later will speak Professor Ferrara, who is coming from Rome. So now is your turn, okay. Maribel.
So I want to start by thank the organization for inviting me to share what I would call really preliminary thoughts on a very tricky matter. So as preliminary thoughts, if you are lucky, you eventually make a good question. That's not much more than that. Okay, so my presentation is on fundamental rights and EU powers. Opposite forces. So, and I have 20 minutes. Okay.
That's right.
During the drafter of the Charter, member states tried to prevent a competence creep via judicial activisms on the field of fundamental rights. To this effect, Article 6 of the Treaty and 51 of the Charter stresses that the Charter will not extend the competences of the Union. Title 7 of the Charter determines both the situations under which the Charter may be invoked and how its provisions are to be interpreted. The goal was to guarantee that the principle of conferral would be complied with. However, the Lisbon Treaty increased the Court of Justice case law on fundamental rights not only by the binding force of the Charter, but also by the extension of the Court's jurisdiction over the area of freedom, security, and justice. In fact, the number of preliminary references related to fundamental rights has grown. Furthermore, the link between fundamental rights protection and the duty to raise the preliminary ruling has been strengthened, the Strasbourg case law being the clearest example. Let me remind you of judgments as Misot versus France or Schipani versus Italy. Thus, it is not surprising that the worry by a quick competence has increased. Nowadays, one of the main concerns of EU lawyers is to determine EU rights scope and with it the Court of Justice constraints in this field. Such a worry is easy to understand because the different understandings of fundamental rights are a consequence of legitimate differences among constitutional systems. The definition in each country of what rights are considered fundamental, as well as the scope of fundamental rights, reflects the value preferences of the citizens of that country, as well as their views on the appropriate division of roles between the legislature and the courts. Furthermore, we must not forget the legal strength of the Court of Justice case law. It can cause deep substantive and institutional changes within the constitutional systems. Therefore, a crucial question is how to strike a balance between EU powers and EU fundamental rights. Or put in a different way, how to guarantee EU rights and to comply with the principle of conferral at the same time. This enormous question has been encapsulated in three big legal constructions by scholars: the scope of the Charter, EU citizenship, and the interpretation of EU secondary law related to fundamental rights. I will briefly mention the former two because I will deal with the third one. The link between the Charter and the EU citizenship has been deeply debated, particularly since the Zambrano case, but currently scholars such as Spaventa even talk about a reduction of the significance of the EU citizenship. A recent example could be Delvin case on prisoners' right to vote in EU Parliament elections. This case could have been a perfect case for elaborating on the citizenship scope. In my view, the citizenship underlines the Advocate General opinion, but the Court of Justice preferred to rely on a complicated connection between the Charter and Article 14 of the treaty. In fact, this is a key concern, the scope of the Charter. On one hand, it is highly controversial to determine when the Charter addresses the member states. The Court of Justice has equated the Charter scope with the fundamental rights scope pre-Charter. The judgment flag may be maybe the last confirmation of this reasoning. This case law has been heavily contested, not only by scholars, but also by key domestic players, such as the German Constitutional Court or the House of Lords. In my view, this case law is at the very least obscure because it is not easy to foresee when the Charter will be eventually triggered. Maybe it's just me, I am a humble, poor constitutional lawyer, but I do not always understand the reasoning of the Court of Justice on this matter. On the other hand, the EU institutions' status regarding the Charter is not fully settled. Scholars, such as Pearce or Claire Kilpatrick, question the answers provided by the Court of Justice regarding the Memorandum of Understanding, the instrument related to the economic governance, and the ESM. Shouldn't the Charter be applicable to these instruments? Shouldn't the Court of Justice confirm its jurisdiction? Up to now, it is shying away from making a decision in this field. Thus, the Charter scope is still far from clear, or at the very least, far from being undisputed. The third issue is the secondary law and the EU fundamental rights. It may be distinguished between EU rules, which give a specific expression to a fundamental rights, and EU rules which incidentally set fundamental rights as standards. As already mentioned, this issue is the main interest of my presentation. In fact, I am going to concentrate on the reasoning followed by the core, especially on the concurrence of competence and fundamental rights concerns on its reasoning. This concurrence will be analyzed on its case law regarding judicial cooperation in criminal matters. Firstly, I will deal with the EU rules incidentally impacting upon fundamental rights, which is the reasoning followed by Luxembourg. Usually, the Court of Justice firstly determines the EU target, and afterwards it deals with the impact of the EU rule upon fundamental rights. If there is a domestic rule involved, the Court of Justice digs into the compatibility of the domestic rule with the EU target, and afterwards with the compliance with other EU principles, one of them being fundamental rights protection. This is a very different reasoning from the one normally followed by general advocates, because they tend to study first whether the EU rule is not in contradiction with fundamental rights, and even when the outcome of both approaches on a specific case might be the same, in the long run, the difference is enormous. A good example is Lopes da Silva case. A Portuguese court issued a European arrest warrant regarding Silva, a Portuguese man who lived in France. The framework decision allows for refusing a European arrest warrant, provided that the state undertakes to execute the sentence in accordance with its domestic law. The French law foresaw such a possibility only if it was requested for a French national. The Advocate General refuses such an interpretation. In his view, the framework decision does not allow member states but the courts to condition the surrender. In other words, it is up to the courts to decide whether the person must be surrendered under the already mentioned condition, because that provision guarantees the resocialization. That's tricky for me to say. Therefore, the French rule was not compatible with EU law. The Court of Justice also declares the French rule not compatible, but on a different basis, the non-discrimination on nationality grounds. States can decide whether to condition or not the surrender, but if they do, they must comply with EU law. This reasoning allows for complying with the goal of the decision framework, the surrender of the person, and leaves room for maneuver to the member states. But if left many cases unprotected, the Advocate General reasoning prevents the violation of the right to family life throughout the European Union. Hence, the Advocate General follows an interpretation in conformity with fundamental rights, as Cruz Villalón explicitly stated in the IV case. In fact, the core reasoning might expand the fundamental rights if it's the goal of the EU law or principle. The connection between the principle of effectiveness on Article 47 of the Charter being maybe the best example. However, a fundamental right might aim at constraining the goal of an EU rule. For instance, procedural rights are a barrier to the power over public order and security, which is the target of the European arrest warrant. In these cases, the primacy of the interpretation in conformity with EU powers might corrode the protection of fundamental rights. Let me give you a recent example. Mr. Lanigan is requested by the UK because he is a former member of the IRA. He claims that his life could be endangered if he were to be surrendered. The procedure to the endorsement of the European arrest warrant lasted almost 30 months, during which Mr. Lanigan, who has not been condemned but accused, was held in custody. Eventually, the Irish Supreme Court raised a preliminary ruling asking, basically, whether the failure to observe the time limits stipulated in the framework decision gives rise to Mr. Lanigan. The court analyzes, firstly, the aim of the directive, the mutual recognition principle, which is very dear to the court, as proven in the opinion about the convention, and confirms that courts must adopt a decision on the European arrest warrant even after the expiry of time limits adopted by the framework decision. Secondly, they dig into the situation of the person who is being held in custody on the basis of the right to liberty. In these regards, ordinary courts may hold that person in custody only insofar as the procedure for the execution of the European arrest warrant has been carried out in a diligent manner and insofar as the duration of the custody is not excessive. If the person is released, the ordinary court must take the necessary measures to guarantee the eventual surrender. This is in principle a very balanced decision, but the court decided to establish the criteria to determine when the duration is excessive. Firstly, for my surprise, the presumption of innocence plays no role. It's out of the picture, because the Court of Justice seems to equate a person accused with the person condemned. Secondly, one of the criteria to be followed is the characteristics of the procedure followed in the case in the main procedures, which has to be ascertained by the court issuing the European arrest warrant. This criterion is striking because it is difficult to assess how to put it in practice by the courts. This reasoning pays particular attention to the powers of two member states involved, but by doing so puts at stake the fundamental right that the court was trying to guarantee. It preserved the powers from the states and for the Union, but maybe not the rights. The perfect balance between powers and rights cannot be achieved in practice. Rights interfere on the competences of the players involved in a complex legal system and vice versa. In order to keep the players' autonomy, a certain degree regarding fundamental rights, a difference must be allowed. Courts must constantly strive to find a stable balance along with their judgments, building brick by brick a valid answer, not a perfect one, from the perspective of both the fundamental rights and the powers of the players involved, mainly EU institutions, member states, and courts. Such an ideal goal requires interpretation which ponder the consequences for the single case and for the whole legal system. The interpretation of secondary law in accordance with the fundamental rights is one of the methods to be applied, let's say the only one, even though it can involve decreasing the powers of the member states or the European Union in certain cases. Furthermore, it can be wise in many cases to declare invalid the EU rule to better protect the conferral principle. Although the Court generally has been quite reluctant to make this decision, it is true that the Court has declared EU rules invalid on the basis of the Charter. But up to now, as far as I am aware, the cases were related to data protection and no discrimination, two fields in which the treaties empower EU institutions to enact fundamental rights legislation. In this regard, let me finish with the Kovaci case related to both the directive on right to translation and interpretation and right to information in criminal procedures. Interesting enough, the EU is empowered to determine minimum rules in these two fields, aiming at ensuring the mutual recognition principle. Mr. Kovaci, a Romanian citizen, was driving a car in Germany without valid civil liability insurance, and that the proof of insurance provided was a forgery. Mr. Kovaci was questioned on those matters by the police with the assistance of an interpreter. As Mr. Kovaci has no domicile or residence in Germany, he granted an irrevocable written authorization in Romanian for 3 officials and returned to Romania. At the end of the investigations, the public prosecutor claimed that a fine should be imposed. But the local court considered that the procedures followed could have been in contradiction with the already mentioned directives. I am not dealing with the right to information, but with the right of translation. According to the German law, Mr. Kovaci could challenge the fine orally or in writing. A lawyer was not required. However, if Mr. Kovaci wanted to challenge it in writing, he was responsible for providing the appeal in German. The Court of Justice recalls that the directives laid down only minimum rules to enhance mutual trust. According to the directive, Mr. Kovaci would have the right to an interpreter if he challenged orally the fine or if he were assisted by a legal counselor. However, if he decided to challenge the fine or if he were assisted by a legal counselor. However, if he decided to challenge the fine in writing, he has no right to translation. The Advocate General points out that the directive must be read in a systematic way. It does not seem logical that Mr. Kovaci is assisted by an interpreter only if he challenges the decision orally. In his view, the target of the directive is to strengthen the rights of the individuals in criminal proceedings, and such an aim must be taken into consideration when confronted with any gap in the directive provisions. The different approach derives from a different understanding of the EU power. According to Article 82, the Union may enact minimum rules concerning the rights of individuals in criminal proceedings. The Court of Justice considers that this provision means that the directive's procedures can be voluntarily completed by the Member States, but the Advocate General considers that the directives contain essential rules for criminal proceedings. That's it why the Court of Justice does not even follow a systematic reading of the directive. The Advocate General approach makes sense to me, but given the difficulties surrounding the negotiations related to the procedural rights, it is likely that the Member States want the Court of Justice approach. However, is a systematic reading of a legal text a far-fetched interpretation? Furthermore, scholars have pointed out that the case law must give flesh of bones to the directives on procedural rights to guarantee the rights that they contain. Such a case law must pay attention to the competences, but also to the rights. Otherwise, we might have a European space in which crimes don't have borders, but procedural rights do. As a matter of fact, Europe might end up supporting a repressive understanding of criminal law without a real collective reflection on the matter. In this regard, a really challenging case has been brought before Luxembourg. The court must answer whether a European arrest warrant can be refused when the detention conditions in the requesting state's prisons fall below international standards. The court has now the chance to answer a question that is being repeatedly brought before the ordinary courts, and by doing so, to establish the conditions under which the European arrest warrant cannot be surrendered. The court can also rely once again on the end of the framework decision, but then it will be forgetting that there are ordinary courts already answering that question, and that this question, eventually, Strasbourg could answer it. The conferral principle cannot be the only answer. The more powers the Union acquires, the greater need for fundamental rights sideward, and different rights requires different safeguards. The reasoning is an essential source, as already pointed out, of legitimacy for cause. Therefore, the Court of Justice should be aware that when it comes to fundamental rights, there are several values and principles on the table that have to be considered. Besides, it should change its practice and style, but I do not have time to dwell on that. However, I think that it's appropriate to finish my participation in a workshop devoted to the possible needs of a new narrative in Europe by stressing that fundamental rights narrative does not necessarily lead to increased support for a project, at least in short term. It might indeed lead to the opposite result. The Court of Justice is probably aware of that. And as a matter of fact, there is a clear relationship between the method of interpretation chosen and the role that a court is actually willing to play. Something time? Okay.
Thank you, Maribel. Perfect timing. Now is the turn for Professor Ferrara. Buongiorno e benvenuto, professore. He's coming from Rome. He teaches at Tor Vergata University. He's a philosopher, specialized in politics. So I think it will be a complementary approach to what we have heard from Maribel. Just your floor.
Thank you. Let me start also by thanking the institutions here, the Institute for Governance and London School of Economics for having organized this excellent workshop in the persons, especially Daniel Inerarity and Jonathan White, and I'm very pleased to be here in Bilbao to present my work as a humble political philosopher and not a specialist in jurisprudence or in constitutional law. I found the general topic that was chosen, the emphasis on narratives, very, very important, because I think, and in the end, my presentation will come down to the need for a more encompassing, a more convincing, a more somehow inspiring narrative for the European Union. But let me start with two questions that are always there in the background. Does Europe have a future as a political project? Will there be a European Union in the first place decades from now? Let me start from a view from afar. Former President of China, Hu Jintao, is reported a few years ago to have answered the question how he would see the world of 2040 by saying, "It will be a world where China and the US will compete tête-à-tête for economic leadership." And then, mindful of being addressing European interlocutors, to have paused for a second and add, of course, also Europe will be there if it will be united. But then, united in what sense? And we've heard about the difficulties in delivering of the European Union, in handling challenges like the rise of political movements that thrive on xenophobic ideas, sentiments of national distrust, and all of these. I won't go through them. I just want to mention the waning role of EU in world politics. I just want to point to the fact that these challenges prompt interrogation about the ultimate sustainability of the constitutional project of the EU. And at that point, constitutional narratives do play a fundamental role because they shape our public perception. And I'd like to contrast here the three such narratives. Which all focus on a key moment, the failed approval of the Constitutional Treaty in 2005 and the incorporation of most of its contents in the Lisbon Treaty. which more modestly eliminates altogether the term constitution in even a metaphorical sense. So the first narrative is called a constitution without a constitution. So a constitution with small c without a constitution with a big C, with a capital C. And this first narrative considers this move a wise one. Joseph Weiler, already mentioned, as he points out, when the common market was created, when Maastricht set the stage for the euro and the EU came into being, even when the enlargement to Central and Eastern European countries took place, no one ever talked of a constitution. To depart from that method, to ignite the rhetoric of a constitutional moment, to even use the adjective constitutional was a deep mistake. What the federalist rhetoric of Giscard d'Estaing, then president of the convention that drafted the constitutional treaty, or of Romano Prodi, then president of the commission, obscured, according to Weiler's narrative, is the specificity of the EU, namely the fact that while a federal process of constitution making entails the transfer of local powers to a more extensive demos, which includes the federated units and exerts ultimate authority, in the case of the EU, certainly there is a priority of EU legal norms over local ones, but there's not a central federal political authority. How can then EU legal norms trump national ones? He calls, here's for Weiler the real uniqueness, the inventiveness, the political creativeness of the EU, its Grundnorm. He calls this the principle of constitutional tolerance. And I quote from him, "The member states accept the European constitutional discipline as an autonomous voluntary act, endlessly renewed on each occasion, an act of subordination to a norm which is the expression of other wills, other political identities, other political communities." The EU, paraphrasing Renan's famous definition of a nation, is a daily plebiscite, not by individuals, but by the member states. At this point comes the crucial question. Couldn't we adopt a formal constitution which would codify, crystallize this constitutional tolerance? And Weiler answers negatively. I quote again from him, "Tolerance is bred by the very fact that constitutional discipline is requested, not required, not demanded, with the authority of a formal constitution backed up by constitutional demos." So for Weiler, rejecting the symbolism and the iconography of a formal constitution, as the Lisbon Treaty does, while subsuming the contents of the constitutional treaty, is a progressive move. Now, the second narrative, called the enduring project of European Constitution, is Habermas's narrative, which was already mentioned earlier. It starts from a similar premise. Europe already is more than a confederation, less than a federation. But in the end, Habermas reaches the opposite conclusion. Europe does need a constitution. And also for Habermas, the priority of European law over state law has already been achieved. But how is this priority to be understood? Where Weiler's introduces his principle of constitutional toleration, Habermas introduces what I think is the most innovative element of his constitutional narrative about Europe. The Maastricht Treaty and the Lisbon Treaty all refer to the idea that sovereignty in the EU is shared between the citizens and the states. And Habermas argues that differently from classical federal states, which supposedly are constituted by the citizenry in its entirety, the foundation of the European Union can be conceived retrospectively as though the citizens, and I quote from him, the citizens involved were split into two personae from the beginning. Every person as a European citizen in the Constitution founding process encounters herself, as it were, as a citizen of an already constituted national people. Thus, differently than in federal states, in the case of the EU, no creation of a supreme constitutional authority occurs. The EU citizens agree to transfer the sovereign rights of their already constituted states to the new polity with a reservation which goes far beyond the usual guarantee of the continued existence of the component states, but which instead, in the case of the EU, requires that the respective states survive within the federal polity in their freedom guaranteeing function of constitutional states. that is to say, as guarantors of rights, including social rights. Now, this narrative of shared or dual sovereignty explains why the citizens of the member states want to share their constitutional power with the citizens of the member states, but not relinquish it to themselves as EU citizens, understood as the ultimate source of the power to amend the supranational constitution. It also this Habermas narrative has the advantage of telling us what EU positively is, not just telling us what it is not a confederation, not a federation, and allows us to pin down the democratic deficit in the current mainly intergovernmental arrangements. Concerning the possible rise of European civic solidarity, Habermas sounds a not too pessimistic note. Considering the idea of a unified public sphere not realistic, he argues that a sufficient degree of transnationalization of national publics can be reached if the existing leading media of each country would thematize and address European issues as such, as well as report on the political positions and controversies which the same topic evoke in member states. This modest change, well within reach, would itself narrow the gap between the interest that citizens have toward their national context and the indifference that they have towards European institutions. And transnational communication across the various public spheres would allow the emergence, for Habermas, of a political identity of the citizens of the EU. Now, in my opinion, and this will be the last point at the end, the one aspect that would further strengthen Habermas's narrative is an exploration of the contribution that to the rise of such political civic identity could be offered by the gravitational pull of a substantive emphasis on the part of transnational political and cultural elites, parties, organizations, and media, the emphasis on the identity-building core of a new constitutional document. And I'll return to this in the end, because I want to go through a constitutional narrative, which has recently been put forward by Bruce Ackerman in an article published in the earlier this year, in the British Journal of Political Science, and part of a larger book project on world constitutionalism. Bruce Ackerman also, in fact, takes a more pessimistic view of the missed constitutional moment of 2004 and 5 and its consequences. He focuses on three distinct and somehow rival constitutional cultures rooted in the different member states. Drawing on his analysis of three distinct pathways through which constitutions have won legitimacy over the past centuries, he argues that all the major pathways to constitutionalizations are reflected in the EU, and they generate conflicting responses to present challenges. In the first case, the first pathway, a revolutionary movement successfully opposes an oppressive regime, either through military struggle or non-violent civil disobedience, and upon winning a final confrontation, establishes a new regime which recasts the ideal animating the struggle in the form of new constitutional principles. Now, the self-sacrifice undergone by the revolutionary leadership strengthens the legitimacy of its shaping the new constitutional principles. In the European context, this is the pathway that has led to the post-World War II constitutions of France and Italy, and later of Poland through Solidarność. In the second case, the new constitutional regime is the product of the response on the part of the ruling elite to challenges and demands for radical change. It is the work of responsive insiders rather than victorious outsiders. Great Britain provides a paradigmatic example. But this path, iterated in Canada, Australia, New Zealand, has no analog in continental Europe. In the third pathway, number three, participation is lacking. The old system of government, it's called the elite constitutionalism. The old system of government begins to unravel, but the general population stays on the sidelines in relative passivity. The emerging power vacuum is exploited instead by previously excluded political and social elites. Sometimes the new elite constitution allows the old elites to retain a significant share of power. Sometimes it doesn't. But whatever the particularities, the key point is that the new regime is an elite construction, not a revolutionary creation. Two paradigmatic cases within the EU are post-Franco Spain, for Ackermann, and World War II Germany, post-World War II Germany. Elite constitutions face a distinctive problem of legitimation. Sometimes they face an authenticity problem, as in the case of Japan, whose constitution was written under the occupation. And in cases such as Germany, at two major historical junctures, in 1949 and in 1989, the constitution was refused to be submitted to popular ratification. And in the case of Spain, there's obviously some questions or some problems in convincing, as Ackermann puts it, the Basque country and the Catalonians of its full legitimacy. Given this diversity of constitutional cultures in Europe, in the EU, it is not surprising that EU countries have trouble finding a common pathway to a more perfect union. Consequently, challenges like the rise of neo-nationalist and populist movements, the financial crisis of the southern European countries, and the not so uncommon problems of redistribution, which affect all federations and confederations, including the United States, exert a much more disruptive impact than elsewhere on the fabric of the European Union. Lisbon, and I quote from Ackermann, and more recent agreements were elite constructions that avoided as much as possible self-conscious consideration by the peoples of Europe at referenda. This decade of evasion between 2005 and now is allowing rising protest movements to present the Union and the Bank as alien forces dominated by harsh technocrats, with Union politicians serving as pseudo-democratic ornaments. Now, these three narratives concur in writing off a straightforward federal Europe, a future for Europe, but diverge in their evaluation of the missed constitutional moment of 2004 and 5 and about the desirability of using constitutional symbolism. And I want to bring out here a possible fourth narrative, or maybe an enrichment of the last two. A narrative with the ability to mobilize people or inspire people, as Jan Komarek suggested before. A narrative which comes down to the point that Europe, the EU, the European Union, can have a political identity and not only an institutional structure. Now, for the two narratives that I examined last, Habermas and Ackermann, the current challenges can be successfully met only through an increased, not a diminished integration of social policies, immigration, social security policies, fiscal policies, and so on and so forth. If so, then progressive elites, I think, and grassroots movements alike should have an interest in tapping the motivational and identification building potential of constitutional symbolism, the one rejected by Weiler. Both Habermas and Ackermann's narratives would be further strengthened by emphasizing the fact that through its essentials, a constitution expresses the identity that unites the members of the political community. A constitution tells the rest of the world who we are and wish to be politically. And I think there is enough substance in the Lisbon Treaty to build a sense of the difference that both EU citizens and the citizens of the member states, to stay within the Habermasian narrative, can be proud of. A proper constitution for Europe needs to give symbolic emphasis. All it needs to do is to give symbolic emphasis to 7 constitutional essentials already found in the Lisbon Treaty version of the Charter of Fundamental Rights of the European Union, which jointly can be said to express the distinctive political identity of the European Union. And these constitutional essentials are, very quickly, first, the explicit prohibition against including death penalty into penal law, an obvious term of contrastive comparison, East and West, with the United States and China. Second, the innovative way in which the right to bodily integrity is understood through the explicit prohibition within medical science and biology of making the human body and its parts as such a source of financial gain, Article 3.2c. Third, the constitutionalization of the right to privacy in Article 7, which is innovative as well. Fourth, the new right to freedom of information, alongside the more traditional right to freedom of expression or free speech. This freedom of information moment in it consists no longer simply of a right of the individual to express her own thoughts without censorship, but also of an obligation to respect the freedom and pluralism of the media, which is different and unprecedented, where pluralism of the media calls for legislation that affects the concentration of media property. Fifth, the constitutionalization of equality between men and women in all areas. Sixth, the constitutionalization, Article 38, of a high level of consumer protection, something of which we might be all very much aware in these days. And seven, finally, the right of the elderly to lead a life of dignity and independence and to participate in social and cultural life, Article 25. Now, these seven constitutional essentials all combined together spell out, I think, in political terms, the human hope referred to by the preamble of the now defunct Constitutional Treaty, a text, the preamble, not included in the Lisbon Treaty, and they sum it up in the following terms. The European Union, this is the narrative, commits itself to be the political space where the dignity of the human being, not just of the citizen, is protected in the most complete way available on this planet. Namely, where under no condition can the state take the life of one of its citizens, residents, or temporary aliens, where the genetic infrastructure of the human being cannot be a source of profit, where no one should be left alone to face illness, where no one should suffer exclusion and indifference along with the inevitable decline associated with the last stages of life, where no one should be left alone to fend for him or herself as a single individual against the economic powers that produce the goods that we consume and the information that we need. And I see no reason why this expanded notion of human dignity, enshrined, embedded in these constitutional essentials in the European Charter, embedded in the Lisbon Treaty, I don't see why this expanded notion of human dignity should not be lifted up from the unreadable legalistic jargon of the Lisbon Treaty to instead become the European dream, as opposed to another dream, well known, the European dream in the hearts of hundreds of millions of citizens of the Union. There is no reason why symbolic emphasis on these constitutional essentials that every European can be proud of, and we usually are proud of when we travel east or west of the Union, should raise any suspicion of a relapse into the dream of a nation-state-like or a federation-like unified demos. There is no reason why this set of constitutional essentials, whose affirmation is fully compatible with Habermas's and Ackermann's narratives, should not become the 21st century finalité of the Union. The answer to the question, what is the Union for? And consign the old answer to that question of finalité, namely preventing internecine war, to the legacy of the 20th century, no longer relevant in the 21st. Finally, elites can draw their much-needed legitimacy from reminding national and supranational constituencies of the truly distinctive political core of the EU identity, can even use loyalty to this value core as a motivating force for constituencies to accept the policies of redistribution needed to keep Europe afloat in the global economy. Parties can draw on such identity core to build more solid transnational bridges. And media can stimulate national debates about ways of strengthening and ways of best implementing and institutionalizing this political core that distinguishes Europe as a political body. Like in a federal state, But without the narrative of a unsustainable narrative of a unified demos, there would be some value core to counterbalance the inevitable divisions rooted in the plurality of interest and national specificities. Thank you for your attention.
Thank you. So now we open the floor for questions. I see, yeah, a couple of hands. Yes, please, Professor White.
Thank you. Couple of questions to Alessandro. So I guess the first question would be about the social forces that you could see advancing such a project. Whose cause is the cause that you outline? One feels that these 7 principles, which I agree can be identified, they are somehow present, but one also feels that to be part of some type of constitutional project, they have to tap into currents which are already somehow in motion and that can be turned into some type of social cause. Because of course these ideas were also around in 2001. Habermas made remarks to this effect perhaps before the constitutional experiment, and one might say the critical problem was the absence of social formations wanting to turn these types of general principle into a cause that could be popularized, give mass resonance, and so on. So where do you see the hooks, if you like, in existing politics and society upon which a cause of this kind might be advanced? And secondly, the bifurcation between the citizen and the member state, which, as you mentioned, is one of the most intriguing aspects of the Habermasian account. Of course, one can see how this can be a productive source of tension. Of course, one can also see how this can be a very problematic contradiction. And I wonder whether you don't have concerns that it may be perhaps at least as much the latter. When I look at the summer of 2015, of course, one of the arguments used to play one member state off against another was exactly the democratic basis of the arguments being made. Germany against Greece as 2 democracies as opposed to simply 2 governments pursuing different agenda. And insofar as a Habermasian account would embed exactly this type of tension between a generalized European will and the will of individual member states, do you not have concerns that that is a tension that's going to come back to haunt European politics persistently?
Well, I think maybe, yes, I think they are extent questions, maybe.
Yes. Well, thanks. Challenging questions. The social forces. It's hard to think of social forces along to identify forces that would support this political core along the lines of the way this question used to be raised in the past, like along with social classes, with social subjects. I don't think there's a dividing line there. There are special classes that or groups or generations, or I mean along any of these classical divides. I think that there's what I tried in a course sort of how can I say, realistic leaning at the end of my presentation. Say, well, actually, I mean, elites are hungry for legitimation all the time, and they're under the suspicion of acting as proxies of special interest, and they should jump on the possibility, in fact, of legitimizing themselves in the name of this political core, which certainly appeals to every European citizen. The moment you travel abroad in the globe, and you find and you find the company of other Europeans, you have this feeling of political commonality around some of these points: the defense of social rights, the no death penalty thing, the disjoining of genetic research from profit. Some version of other of this political mix, which is healthy, is not is not bound up with that prepotencia, this pretentiousness that was evoked earlier in the morning. This kind of posturing. Cultural posturing, but it's a political form of identity. So I think that the social forces could be a combination of the need of elites, of national elites for legitimizing themselves, of parties to build transnational alliances on grounds other than interests, other than cost and benefits, but on emphasizing one or the other aspect of this common core, and for media to create a kind of European discourse. I can't think of those forces any differently. And the other thing is the global scene. If we as as citizens of the EU look at the global scene and ask the question, what is distinctive of us? Politically speaking, because culturally speaking, you can think of many things, but then it's a different kind of discourse, which does not belong in political theory and constitutional theory and so on. Politically, what distinguishes us, it comes down to that core. So that kind of, in the way, that kind of process could lead to the emphasis on, or the acceptance of the affirmation of this political core. And the second part, the tensions between us as citizens of the EU and member states, sure, it could be a tense relation, but that's a film. We have already seen in states that are latecomers to the game of nation states, like I'm thinking of Italy and Germany, states that as nation states have come into being in the second half of the 19th century, and there you had the pressure of local loyalty to community, and the gradual building of a national loyalty. It takes time, but it's a way. It's done by way of fostering on a national basis an emphasis on the good or the advantage of the union as such, which is again is the responsibility of the actors that were mentioned earlier. That's how I would go about answering those two challenging questions. Thanks.
Yeah, thank you. We have 15 minutes left, and there are a lot of people who want to make questions, so we will try to adjust to these circumstances. All right. So please, yeah.
Okay, so I don't know who's okay. Thank you. Sorry. So I'm very sympathetic. My question is for Professor Ferrara, and I'm very sympathetic to the last to the suggestion in the last part of your talk, and I think most of European idealists, especially intellectuals, would be sympathetic to this way of seeing this. I'm also sympathetic to the comment that you just made that implies something that I experienced when I lived away from Europe, a few years in Canada, a year in New York, that Europe is better seen from the distance, you know. When you zoom out from the picture, then suddenly, maybe in New York, you feel more like a European than actually when you are here. And the question is, I don't have, whether this is provides just a very too thin source of a common identity, which is not a problem, especially in a world where people have hyphenated identities, and you can revise your choices and commitments constantly, and this becomes suddenly a good thing. So, and therefore this cannot be a bad thing. But however, I doubt whether it's thick enough to provide the type of bonds that you need, and I'm going to speak in the afternoon about this, in times of crisis. So I'm afraid many sociological studies show that when you really need a sort of cooperation that it's not rationalistic, as Carlos Closa before highlighted, but it's a more altruistic form, moralistic form of cooperation, then you tend to be, your empathy is reduced. Suddenly I'm not European, I'm a Spaniard, or I'm Greek. Suddenly I'm not a Spaniard, but I'm a Catalan. And when decisions from the European institutions have very strong distributional consequences and affect fairness among peoples and groups, then it seems to me that you don't have any means to overcome this crisis unless you have enough bonds, like the bonding, not the boundary, but the bonding has to be stronger in order for people to overcome our natural tendency to be egoistic and to engage in a sort of cooperation that is altruistic. And it seems to me that the crisis, the Greek crisis and the German response shows just this, that the bonds are just too thin, that dignity is not enough.
Thank you. Professor Komarek and Professor, yeah.
Thank you very much. I will have two short questions to both speakers. The first to Professor Ferrara, and it relates to how to understand the concepts you suggest, and then the language of the Constitution is also the language of exclusion. And I was just wondering if you accept this, that it's also about drawing boundaries in the sense that this is Europe, this is not Europe. And to me, in the previous constitutional talks, this was not really mentioned, or it was even rejected in the sense, because Europe likes to be open to everybody, and Europe is being about inclusion. But to me, it's also the time to speak about excluding something and saying something is not part of Europe, and there are some boundaries. And that's, I think, inherent in creating this project. And a very short question to Maribel as well, on fundamental rights, because there is, of course, this problem with the tension between fundamental rights and the powers of the European Union. And I wondered, then for you, fundamental rights, there is no fundamental distinction between fundamental rights in Europe and in the member states. And why I ask that, to me, fundamental rights in the European Union are very much linked to what the project is very much about. So they are very much linked to the common market project and perhaps the project of collective security. And they are not the kind of rights you will get in a national democracy. So then, to me, it then makes sense to draw these boundaries and have them limited. But maybe you have different views on this.
Thank you. I have one question that could be broken in three parts for Alexandro Ferrara. I really like your presentation, in particular your attempt to propose a new narrative. I think is very valiant of you to come forward in this way. But I have several doubts I will address first to the substantive contents of your proposal, and then to what I think is essential, the formal dimension. As for the substantive dimension, just two things. First, in what respect an organization committed to human dignity as the basis of its constitution could really claim a basis for expanding its activity beyond human dignity? On other basis, how you can translate the legitimacy deriving from defending human dignity for all other areas of activity? You could argue that your catalog of rights is very thick, because you're including here constitutionalization of equality between men and women, consideration of consumer protection, and so on and so forth. So that leads me to the second question. How you translate such a thick, relatively thick constitution based on fundamental rights within a pluralistic order? It's not enough to speak about certain rights, and prohibition of death penalty is perhaps self-evident what the meaning is. But how you translate, for instance, constitutionalization of consumer protection vis-a-vis questions like defense from genetically modified products, which is totally divergent in countries like United Kingdom or Spain vis-a-vis the position that Germany has taken on that. This has to be reckoned and taken into account in the model. It's not enough that you really identify certain values, but those certain values, when they are constitutionalized, they need to leave a lot of margin for pluralism. And this is the place in which the values crack, because it's not easy to have a value that is so flexible, that allows for a very pluralistic understanding. Sorry, I am speaking about values, really should speak about rights. And then we come to the formal question, which is, and I was talking with Christian about that, so it's a joint question between Christian and myself, right? To my understanding of constitutionalism is always an implicit decision between what we put in the Constitution and what we leave for normally day-to-day routinary politics. So what you have here in your Constitution, in your notion of constitutionalism, is a strong defense of a catalog of rights, but where are politics in your Constitution? I haven't seen any construction about that, and you say, okay, we need to really to focus on what really links all of us around common values, and you select a number of rights, but it seems that you're suggesting that we are unable to agree on the basis of living together, which is democratic policy making. In your constitutional structure, I didn't see any element of policy, politics, democracy. So this thing, which is inherent to the notion of constitution, is missing. Fundamental rights is there, but politics is not. So I find it a little bit unbalanced and uncurated. Thank you.
Okay, I think it's better than you give answers now. We will continue later.
Okay, thanks for the questions, because it goes straight to the heart of the problem of the fundamental rights and competence within the EU. I do think that we have a different, and we don't have a different view, sorry. Actually, I agree with you that there has to be the strike of balance, actually, but which is the aims of the European project and which are the member states. But when it comes, for example, to European public order or collective security, what I do think is that if you have decided to share the responsibility of the security, you have also to take into account to what extent you can really share the protection of fundamental rights. So what I have chosen are the cases on purpose, in which it is clear that states alone cannot protect the rights when you have transfer to the European Union in the European arrest warrant a certain capacity.